It's not just that this guy told a little white lie. Remember what I said before? These trials are all about credibility. These cases are all about credibility. So now a jury is evaluating the injured patient's credibility. Are they believable? Is what they are saying, does it make sense? If the answer is yes, now hopefully they'll give us a verdict in our favor. If the answer is no, you're out of luck. Your client gets nothing. So, why can this little white lie destroy your client's case? It can destroy your client's case because at the very end of the trial, the defense attorney is going to ask the judge to give the jury a legal instruction that is going to devastate us. And that instruction also has a Latin phrase to it. And the moment I tell you what that Latin phrase is, you're going to immediately realize what I'm talking about. That Latin phrase is called falsus in uno. And what that really means, and what the judge tells the jury, listen, if you find that a witness has testified falsely about one thing, you have the right and ability to disregard part of their testimony. And then he continues, you also have the right to disregard all of this witness's testimony. Telling that little white lie now has empowered the jury to disregard your client's entire line of testimony, which means they could turn around, and if they didn't have a reason to before, now they do. Now they can turn him out of court. Why? They didn't like the fact that he lied about something inconsequential. And I can stand on my head and argue to the jury all day that that had nothing whatsoever to do with the claims of malpractice in this case, of the doctor violating the basic standards of medical care. Doesn't matter. The judge gives the jury that legal instruction. That's all empowering. That's all they need to know. You, the injured patient, you're gone. You get nothing. Goodbye. While I'm on the topic of juries, you should know that when a jury is asked to evaluate a case like this, they have to answer a series of questions. And the answers to those questions formulate their verdict. It's not simply, are you giving a verdict to the plaintiff? And now how much? No, it's a bit more involved. The first question that typically is asked is, was the defendant doctor negligent? Was he careless? Did he violate the basic standards of medical care? Yes or no? If the answer is yes, they go on to question number 2. Because remember, we have to show liability, causation, and then damages. So if they answer yes, they go to the next question. If they say no, the doctor did not violate the standard of care, he was not negligent, case is over. We go home, nothing. But if we can show that the doctor was careless, and now the next question is, was the doctor's negligence a proximate cause of this patient's injuries? And that asks, is there a link between the wrongdoing and the injury? If the answer is yes, now they go on to determine how much money this patient is entitled to receive. If the answer is no, then the doctor has done a good job in one of those defenses saying, hey, I may have done something wrong, but don't blame me because whatever I did didn't cause or contribute to your injuries. And then the jury will have to answer the elements of damages. And there are many different types. There's pain. There's the suffering that the patient endured from the time of the wrongdoing until the time of trial. And then from the time of trial into the foreseeable future for the remainder of this patient's life. We call this non-economic damages. The jury will also be asked to evaluate economic losses, assuming there are economic losses. So let's say your client was no longer able to work and was earning $100,000 a year. Okay, it's easy to calculate. They've been out of work for 3 years, they lost $300,000, and now they'll have the doctor talk about their inability to work, they're permanently damaged and disabled. And now this client is expected to live for the next 25 years. And the jury can extrapolate, and we can bring in economists to talk about the value of money today and the value of money in 20 years from now. So now the jury has a better understanding of the value of a dollar today and the value of that same dollar 20 years from now. So these are some of the things that should be going through your mind as you begin to ask yourself, what type of injury does this person really have? Is this a case involving a minor injury, involving bruising, something that's going away after a short period of time? Or is this something a bit more permanent, long-lasting, disabling, that will affect him for the rest of his life? The answer makes a big difference. And the decision that you make will likely lean in favor towards someone who has that permanent injury. A patient who has a temporary or a minimal injury doesn't mean that they don't have a case. It simply means that it may not be, likely will not be viable enough for you or another attorney to take on, because an attorney invests a considerable amount of time, energy, and resources to take on these cases. And unless you know at the very beginning that this case has a significant value, it's going to be very challenging to go forward with a case.